My name is Chu Machinye, and I am your family lawyer. I'm here again, and it's my great pleasure to welcome you to Your Family Lawyer, the podcast where law meets legacy. Please do not forget to click the subscribe button and turn on your notification bells so that you can watch more of this podcast. If you need legal consultations or advice, please call us today by dialing the number on your screen or send us a WhatsApp message. Now, today's topic touches the very soul of family enterprise. We're going to talk about business succession planning in Nigeria. A successful patriarch built a business empire over decades. He passes on, and what follows is not a smooth transfer of legacy, but a bitter family feud, loss of business value, and in many cases, total collapse of the empire. Now, what this means is you labor for a lifetime, and then you go, and all that you labored for goes with you because of family squabbles, because you failed to plan how your business can transit to the people you left behind. So today, we're going to be talking to you about how to avoid this. Whether you're a successful entrepreneur, a senior executive, an investor, or a moderately successful family patriarch looking to protect what you've built, this episode will unpack the smartest legal tools for wealth transfer. It will show you how to deploy them, how to safeguard your assets from hostile boardrooms, second marriages, side chicks, sugar boys, and even greedy family members. We'll take a legal, a cultural, and a practical journey into what it means to plan your succession in the right way. Business succession in Nigeria operates within a hybrid legal framework, blending statutory law, common law, customary law, and corporate governance principles. The Companies and Allied Matters Act in Nigeria is the bedrock of corporate existence and succession in Nigeria. It regulates the formation, the management, and dissolution of companies. Lawyers call it CAMA. Under CAMA, provisions exist for transfer of shares, appointment and removal of directors, and restructuring of company ownership. Importantly, CAMA allows for family-owned businesses to be structured using holding companies and family-owned private limited liability companies. Of course, we've talked about it a lot, but wills also empower individuals to dictate how their property, including their business interests, should be shared when they are gone. Testamentary freedom is a core principle, but this freedom must be exercised with precision to avoid ambiguity or the disinheritance of loved ones, which leads to battles, fights over who gets what. There is also the trust law, which governs the process of setting up trusts and provides guidelines of how trustees should operate. Trusts can be used to preserve wealth and ensure continuity in businesses. Trustees hold properties for beneficiaries, allowing the founder to define who benefits from business income and who manages it, even whilst he's alive, in retirement perhaps, or when he's gone. Let's look at what the Securities and Exchange Commission laws and guidelines say. These laws govern businesses registered with the Nigerian Stock Exchange and other regulated entities. It governs share transfers, insider trading concerns, and compliance. Relevant as well is the Investment and Securities Act and SEC guidelines, Securities and Exchange Commission guidelines. These laws and guidelines govern businesses that are registered with Nigerian Stock Exchange, and it regulates share transfers, insider trading concerns, and compliance comes into play during succession. Let's look at the related legislation, the Investment and Securities Act, and also the Securities and Exchange Commission guidelines. These two govern businesses that are registered with Nigerian Stock Exchange and other regulated entities. Now, it deals with things like share transfers, insider consents, and issues pertaining to compliance during succession. We should also talk about customary law for family run businesses that are tied to customary land, relating to markets, for instance, community resources such as forest. Customary rules often influence who inherits or manages these kind of businesses and assets. In some ethnicities, only male children may traditionally succeed. So you need to be proactive to think of what to do to circumnavigate this lawfully. Let's look at some legal and financial tools that aid succession planning. A well-designed succession plan or strategy should combine legal precision, financial foresight, and well-guided family engagement. This is how you do this. To show you precisely how it ought to be done, let us explore some key legal tools first. We'll dissect the legal basis, the practical uses of these tools, and explain how you deploy them effectively. We'll talk about the ubiquitous name wills, which remain the simplest but most overlooked tool for family business succession. A well-crafted will should clearly state who inherits what, distinguish personal assets from business assets, appoint executors who understand the business terrain, and who will take charge from when the business owner passes on. A will that fails to make provisions for key dependents can spark litigation. For business founders, a well-tailored will is not a luxury. It's an obligation to yourself, something you owe to your family, and even your business associates and co-owners. You could also make use of trusts, which allow for control beyond the grave. A founder or business owner or a shareholder may set up a living trust to transfer shares during his or her lifetime. Through this, you may also create a testamentary trust, which can be activated upon your death. For example, a father may direct through a trust that profits from his petrol station business be used to educate his grandchildren, whilst trustees manage the operations. Trusts are used to shield minors, limit reckless spending, and prevent fragmentation of business upon the demise of the owner. You could also use transition mandates. These are internal instruments that are created and deposited with banks, often in concert with your bankers, your legal advisors, or your company secretary. They empower successors to have access to key accounts or signed documents whilst you're still alive. They can also be used to authorize change of signatories or operational control. Without these, family members often face locked out accounts, frozen payrolls, and hostile takeovers upon the death of the owner. It aids smooth transition, particularly if you are going into retirement or you fear that ill health might prevent you from continuing to function optimally. The next one I'll talk to you about is not too common, too popular in Nigeria. It's the use of a family constitution, which is a forward-thinking, values-based framework that complements legal documentation in family business succession. In Nigeria, there's increasingly, and I use the word increasingly with caution in relative terms, it is increasingly adopted by progressive families who want to preserve their legacies and avoid destructive disputes, and also institutionalize professionalism within the ranks of the family members. While some think that a family constitution is not enforceable by the courts, I beg to disagree, because in my years of practice, I have not found any reason for which a skillfully drafted family constitution, duly signed by willing adult members of the family, clearly setting out the terms, the considerations, the rights and obligations of the members of the family, cannot be binding and legally enforceable. If you are desirous of making a proper family constitution, you know how to reach us. Nevertheless, a family constitution serves as a strong moral contract, especially when supported by legal tools like wills, trusts, shareholders agreements, and perhaps holding companies. It is one of the most reliable blueprints for generational continuity in the evolving landscape of Nigerian family wealth. And I strongly recommend that families should consider drafting family constitutions, particularly if they have businesses. Wealthy persons may also use gifts inter vivo, that is, gifts made during their lifetime, to plan their succession. This means gifting your assets during your lifetime. Nigerian courts uphold such gifts if the giver intended to give delivered the gift and the recipient received and accepted. For instance, a father could gift business shares to a son with transfer forms signed and submitted to the Corporate Affairs Commission whilst he's still alive. The pitfall for this is that if done under duress or whilst mentally impaired, the gift may be reversed. It is best used when you want to transfer property or cash discreetly during your lifetime and avoid the pitfalls of wills and perhaps trusts. There must be a clear intention, there must be delivery, there must be acceptance. If properly done, it will help you and your descendants to avoid probates. But note that this gift may be challenged if it is found that you lacked capacity to make the gift or it was done under duress. Then there is joint ownership and survivorship. This is a common law doctrine. If you hold property or an account as joint tenants, when one of the joint tenants dies, the other automatically takes full ownership. The way to use it: register the property or bank accounts in both names using phrases like joint tenants, joint account, with rights of survivorship. An example: a husband and wife who own a flat jointly. If the husband dies, the flat automatically belongs to the wife. Let me warn you of a slight technicality that you must be aware of. If the ownership is what is called tenancy in common, that is, it is not specified as joint tenancy between you and the person, the survivorship doesn't apply. The person cannot inherit. The courts look at the intention of both parties. Simply stating that jointly we own the property doesn't automatically pass the property to the survivor. What the intention was must be clearly evident in the documents and in the way you have handled it before the death of the person who died. When it comes to joint ownership of property, the court often looks at the intention. The intention can be found in the documentation, the wordings, and perhaps in the actions or inactions of both parties before the death of one of them. It is based on common law, and it is best used when you want property to automatically pass to a co-owner at death, typically used between a husband and a wife. And to be sure of this, make sure to use words like joint tenants with right of ownership in the deed documenting the ownership. The greatest benefit is that it overrides a will, and it helps you also to avoid probate. Rather than direct ownership, savvy founders of companies and businesses usually create a holding company that owns shares in the operating businesses, which are owned by family trusts or structured shareholding instead of owning properties personally. Another way of preserving your property beyond your lifetime is the use of holding companies. Rather than direct ownership, savvy founders create a holding company that owns shares in operating businesses, which are owned by family trusts or structured holding. Instead of owning properties personally, transfer them into a special purpose vehicle called a holding company. Then transfer the company shares to your heirs. This creates a buffer between personal life and business continuity. A family constitution, which we've just talked about, or a charter, can guide the management and values of this holding company. The benefit is that assets don't pass through probate. Only the shares in the holding company will pass through probate. And the strategy for this is often to use it in combination with trusts and wills so that everything can move seamlessly after your death. If you're in doubt as to what to do, talk to a good corporate lawyer or give us a call. We will guide you. This is often best used when you want to consolidate family assets shield ownership, and pass shares through to the next generation without hiccups. It can be used to preserve real estate, stocks, and other assets which are within the ownership of companies. Another important tool for wealth management and transfer is life insurance and pensions. Life insurance and pensions are crucial for both financial security and wealth transfer. Life insurance provides a death benefit, enabling beneficiaries to cover expenses, to pay debts, or transfer assets. Pensions offer a steady income stream during retirement, which can be used to support dependents or contribute to an estate. Of course, the legal framework for these include the Insurance Act and the Pension Reform Act. And they are best used when you want to ensure immediate liquidity for dependents. But you need to be careful. There have been many cases where somebody who is a beneficiary of an insurance is eager for the person who took out the insurance to go quickly so that he could get the money. Be sure to subscribe, like, and share this episode to your family members and friends or business associates. In the meantime, stay informed and be empowered. And please, by all means, be good to your family. My name is Chu Machinye, and I am your family lawyer.